Question 1. In a situation where formal requirements conflict with evolving technological realities, how should courts interpret the Fourth Amendment's protection against unreasonable searches and seizures in the context of digital privacy? Police department conducts warrantless searches of suspects' cloud storage, arguing that digital files are analogous to physical documents stored in filing cabinet, which could traditionally be searched with lesser Fourth Amendment scrutiny. The suspect argues that the search violated their reasonable expectation of privacy. Given the Supreme Court's rulings on digital privacy, which legal standard is most appropriate for assessing the constitutionality? Search. A. The physical trespass test from United States v. Jones 2012, which requires physical intrusion for Fourth Amendment violation. B. The third-party doctrine from Smith v. Maryland 1979, which holds that data shared with service providers has no reasonable expectation of privacy. C. The reasonable expectation of privacy test from Katz v. United States 1967, which protects private communications similar to phone calls. D. The exigent circumstances doctrine, which allows warrantless searches if law enforcement faces immediate threats. Answer. C. The reasonable expectation of privacy test from Katz v. United States 1967. Explanation. The Fourth Amendment protects individuals against unreasonable searches and seizures, but its application to digital privacy has evolved significantly. Courts have increasingly recognized that traditional Fourth Amendment doctrines must be adapted to technological changes. A. Incorrect. The physical trespass test from United States v. Jones 2012 applies when there is a tangible intrusion, such as attaching a DSRC to a vehicle. Since cloud storage involves no physical intrusion, this test is not appropriate. B. Incorrect. The third-party doctrine from Smith v. Maryland 1979 held that individuals lose Fourth Amendment protection over information shared with third parties, e.g., phone records. However, Carpenter v. United States 2018 limited this doctrine by ruling that law enforcement requires a warrant to access certain digital records, such as historical cell site location data. C. Correct. The Supreme Court in Katz v. United States 1967 established that the Fourth Amendment protects people, not places, and extended protection to private conversations in public phone booths. Precedent has since been applied to digital privacy cases, supporting the argument that individuals maintain a reasonable expectation of privacy in their cloud-stored data. D. Incorrect. The exigent circumstances doctrine allows warrantless searches in emergencies, e.g., preventing imminent harm or destruction of evidence, but it does not create a blanket exception for digital searches. Thus, courts increasingly use Katz in its such as Riley v. California 2014 to recognize robust Fourth Amendment protections in the digital age. Question 2. During a comprehensive review of a process that needs improvement, a state legislature enacts a new law requiring all out-of-state businesses operating within the state to obtain an additional license, even if they are already licensed in their home state. A national trade association challenges this law under the Dormant Commerce Clause. What is the most likely outcome if the case reaches the Supreme Court? A. The law will be upheld under the principle of federalism, as states have the right to regulate businesses within their borders. B. The law will be struck down because it places an undue burden on interstate commerce without a legitimate local benefit. C. The law will be upheld under the Equal Protection Clause, as it applies equally to all businesses regardless of their origin. D. The law will be struck down under the Necessary and Proper Clause, restricts states from regulating commerce. Answer. B. The law will be struck down because it places an undue burden on interstate commerce without a legitimate local benefit. Explanation. The Dormant Commerce Clause is an implied restriction that prevents states from enacting laws that unduly burden interstate commerce. The Supreme Court has developed a balancing test for these cases, primarily through Pike v. Bruce Church, Inc. 1970, which assesses whether a state law places excessive burden on interstate commerce relative to its local benefits. A. Incorrect. While states have general regulatory authority under federalism, this power is not unlimited. The Dormant Commerce Clause prevents states from imposing protectionist regulations that disrupt the national market. B. Correct. Under Pike v. Bruce Church, the Supreme Court weighs 1. The burden on interstate commerce against 2. The legitimate local interest served if a law creates unnecessary barriers for out-of-state business. Without clear local benefits, it is likely unconstitutional. In cases like Granholm v. Eel 2005, The court struck down state licensing requirements that unfairly discriminated against out-of-state entities. C. Incorrect. The Equal Protection Clause, 14th Amendment, is concerned with discrimination against individuals, not burdens on interstate commerce. Even if the law applies equally to all businesses, it can still violate the Dormant Commerce Clause if it disproportionately affects interstate commerce. D. Incorrect. The Necessary and Proper Clause, Article I at Section 8, grants Congress the power to enact laws related to its enumerated powers but does not directly restrict state laws. State regulation of commerce is limited by the Commerce Clause, not the Necessary and Proper Clause. Thus, under Dormant Commerce Clause framework, this licensing requirement would likely be struck down as an unconstitutional barrier to interstate trade. Question 3. In a situation where resource allocation becomes a major challenge, Congress passes a law delegating broad regulatory authority to an executive agency to oversee environmental protections, including setting carbon emissions limits. A lawsuit is filed arguing that Congress has violated the non-delegation doctrine. What is the most likely constitutional analysis of this delegation? A. The delegation is unconstitutional because it gives an executive agency legislative powers, violating the separation of powers. B. The delegation is constitutional as long as Congress provides an intelligible principle to guide the agency's actions. C. The delegation is unconstitutional under the Necessary and Proper Clause as Congress must retain all lawmaking authority. D. The delegation is constitutional because executive aid are inherently allowed to make laws under administrative law principles. Answer. B. The delegation is constitutional as long as Congress provides an intelligible principle to guide the agency's actions. Explanation. The non-delegation doctrine stems from the principle that Congress cannot transfer its legislative powers to another branch without clear guidance. However, the Supreme Court has largely upheld congressional delegations as constitutional under the intelligible principle standard established in J. W. Hampton, Jr. and Company v. United States, 1928. A. Incorrect. While the non-delegation doctrine exists, the Supreme Court has only struck down delegations twice in history, both in Schech to Poultry Corp. v. United States 1935 and Panama Refining Company v. Ryan 1935. Courts have since upheld broad delegations as long as Congress provides some guiding standards. B. Correct. Under the J. W. Hampton standard, an agency's authority constitutional if Congress provides an intelligible principle for the agency to follow, such as setting emissions standards based on scientific data. Cases like Whitman v. American Trucking Associations, 2001, reaffirmed this principle. C. Incorrect. The Necessary and Proper Clause grants Congress broad lawmaking power, but it does not require Congress to personally execute all laws. It allows delegation within limits. Incorrect. While administrative agencies can create regulations, they cannot make laws unless delegated authority by Congress. Agencies are not inherently lawmaking bodies under the Constitution. Thus, the agency's authority would be upheld if Congress articulated an intelligible principle to guide its regulatory actions. Question 4. During an emergency response where multiple areas are impacted, a newly enacted federal law grants the President broad powers to declare a national emergency and implement executive orders that override state laws in the interest of public safety. A coalition of state governors challenges the law, arguing that it violates the principles of federalism and the 10th Amendment by stripping states of their reserved powers. The federal government defends the law by citing the Supremacy Clause and the Necessary and Proper Clause. How should the Supreme Court evaluate the constitutionality of this law? A. The law is unconstitutional because it violates the 10th Amendment, which reserves powers to the states unless explicitly delegated to the federal government. B. The law is constitutional under the Supremacy Clause, as federal law takes precedence over conflicting state laws in matters of national security. C. The law is unconstitutional because it exceeds the scope of the Necessary and Proper Clause, which does not grant Congress unlimited authority. Override state sovereignty. D. The law is constitutional because the President has broad emergency powers under Ticker Omen which allows for executive action in times of crisis. Answer A. The law is unconstitutional because it violates the 10th Amendment, which reserves powers to the states unless explicitly delegated to the federal government. Explanation. The 10th Amendment reserves powers to the states unless they are explicitly granted to the federal government, while the Supremacy Clause, Article Roman, establishes federal law as supreme over conflicting state laws. It does not automatically justify overriding state authority. All cases. The Necessary and Proper Clause, Article I, Section 8, grants Congress the power to enact laws necessary to execute its enumerated powers, but it does not provide unlimited authority to federal agencies or the executive branch to display state sovereignty. Furthermore, presidential emergency powers under Article Omen do not grant unilateral authority to override state powers without congressional authorization. Therefore, Supreme Court would likely find that the federal law violates the principles of federalism and the 10th Amendment. Question 5. When implementing new protocols in a shared environment, a public university implements a policy requiring student organizations to obtain prior approval before hosting political speakers on campus. The university claims this measure is necessary to maintain campus safety and prevent disruptions. A student group challenges the policy, arguing it violates the First Amendment's protection of free speech. The university that it has compelling interest in regulating campus events. How should the court analyze this case? A. The policy is constitutional because universities have the authority to impose reasonable time, place, and manner restrictions on speech. B. The policy is unconstitutional because it constitutes prior restraint, which is presumptively invalid under the First Amendment. C. The policy is constitutional because public universities have broad discretion to regulate speech on campus to maintain order. D. The policy is unconstitutional because the First Amendment prohibits all regulations on speech in public forums. Answer B. The policy is unconstitutional because it constitutes prior restraint, which is presumptively invalid under the First Amendment. Explanation. The First Amendment protects free speech, and any regulation that requires prior approval before speech can occur is considered prior restraint, which courts have consistently deemed presumptively unconstitutional. The Supreme Court has ruled that prior restraints are permissible only in exceptional circumstances, such as national security threats near v. Minnesota, 1931. While universities can impose time, place, and manner restrictions on speech, Ward v. Rock against Racism, 1989, such restrictions must be content-neutral, narrowly tailored, and leave open ample alternative channels for communication. A blanket requirement for pre-approval of political speakers likely fails this test, making the POT unconstitutional. Question 6. In a situation where formal requirements conflict with constitutional principles, Congress passes a law mandating that all federal judges must retire at the age of 70. The law is challenged in court on the grounds that it violates the constitutional principle of judicial independence. The challengers argue that the Constitution establishes lifetime tenure for federal judges under Article Roman 3. How should the Supreme Court? A. The law is unconstitutional because Article Roman provides that federal judges serve during good behavior, meaning lifetime tenure unless impeached. B. The law is constitutional because Congress has the power to regulate judicial qualifications under its general legislative authority. C. The law is constitutional because the Necessary and Proper Clause allows Congress to enact laws ensuring an efficient judiciary. D. The law is constitutional because it violates the Equal Protection Clause by discriminating based on age. Answer A. The law is unconstitutional because Article Roman provides that federal judges serve during good behavior, meaning lifetime tenure unless impeached. Explanation. Article Roman 3, Section 1 of the Constitution states that federal judges shall hold their offices during good behavior, which has been consistently interpreted to mean lifetime tenure unless judge resigns, dies, or is removed through the impeachment process. Congress does not the authority to impose mandatory retirement age on federal judges because it would undermine the constitutional principle of judicial independence. The Supreme Court has historically rejected attempts by Congress to modify judicial tenure outside of constitutional mechanisms. The Equal Protection Clause, answer D, applies to state actions, not federal judicial tenure. Question 7. During a comprehensive review of a process that needs improvement, a state legislature enacts a law requiring voter ID for all elections. The law is challenged under the 14th Amendment's Equal Protection Clause and the 24th Amendment's prohibition on poll taxes. Plaintiffs argue that the law disproportionately disenfranchises low-income and minority voters. The state defends the law as a necessary measure to prevent voter fraud. What constitutional analysis should the court apply? A. The law is unconstitutional under the 24th Amendment, which prohibits all forms of voter identification requirements. B. The law is constitutional because states have the power to regulate elections under Article I, Section 4. C. The law is unconstitutional if it imposes an undue burden on the right to vote under the Equal Protection Clause. D. The law is constitutional because preventing voter fraud is compelling state interest. Answer: C. The law is unconstitutional if it imposes an undue burden on the right to vote under the Equal Protection Clause. Explanation: the Supreme Court applies strict scrutiny when a law burdens the fundamental right to vote. Harper v. Virginia Board of Elections, 1966. While states have authority under Article I, Section 4 to regulate elections, such regulations must not disproportionately disenfranchise voters. Crawford v. Marion County Election Board, 2008. If the law places an undue burden on certain groups, it may violate the Equal Protection Clause of the 14th Amendment. The 24th Amendment prohibits poll taxes but does not categorically ban voter ID requirements. If obtaining voter ID requires significant cost or effort, courts may consider it an undue burden. Question 8. In an effort to balance economic interests with constitutional protection, a state government enacts a law prohibiting private businesses from refusing service to customers based on political beliefs. A business owner challenges the law, arguing that it violates their First Amendment right to free speech and freedom of association. The state defends the law by citing its compelling interest in preventing discrimination in public accommodations. Should the court evaluate the constitutionality of this law? A. The law is constitutional because the state has broad authority to regulate businesses operating as public accommodations. B. The law is unconstitutional because it compels speech in violation of the First Amendment. C. The law is constitutional under the Equal Protection Clause as it ensures that all individuals receive equal treatment in businesses. D. The law is unconstitutional because businesses have an absolute right to refuse service to a customer for any reason. Answer: B. The law is unconstitutional because it compels speech in violation of the First Amendment. Explanation: the First Amendment protects individuals and businesses from compelled speech. The Supreme Court has ruled that forcing businesses to convey messages they disagree with may violate their free speech rights. West Virginia State Board of Education v. Barnett, 1943. Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston, 1995. While states can regulate public accommodations to prevent discrimination, they cannot require private businesses to endorse or express messages they oppose. The law in question likely compels businesses to express ideological approval of customers' political beliefs, making it unconstitutional. Question 9. When a law restricts public participation in governmental decision-making, a state legislature enacts a law limiting public attendance at government meetings to individuals with official invitations, citing concerns over security and efficiency. A civic group challenges the law, claiming it violates the First Amendment's right to petition the government and the 14th Amendment's Due Process Clause. How should the court rule? A. The law is constitutional because the government has broad authority to regulate meeting attendance for security reasons. B. The law is unconstitutional because it restricts the right to petition the government and participate in public affairs. C. The law is constitutional under the necessary and proper clause as it ensures government operations run efficiently. D. The law is unconstitutional because it imposes prior restraint on speech. Answer: B. The law is unconstitutional because it restricts the right to petition the government and participate in public affairs. Explanation: the First Amendment guarantees the right to petition the government for a redress of grievances. Restricting public access to government meetings severely limits political participation and transparency. Additionally, the 14th Amendment's Due Process Clause ensures the public has access to government decision-making that affect them. Courts have ruled that government meetings should generally remain open unless compelling interest justifies restrictions. Richmond Newspapers, Inc. v. Virginia, 1980. Question 10. In situations where religious freedoms conflict with anti-discrimination laws, a religious non-profit organization refuses to hire an employee because of their religious beliefs, citing a religious exemption under federal law. The rejected applicant files a lawsuit claiming religious discrimination under Title IX of the Civil Rights Act. The nonprofit argues that the First Amendment's Free Exercise Clause protects its right to employment decisions based on religious beliefs. Which legal principle should the court apply? A. The nonprofit is protected under the ministerial exception, which allows religious organizations to hire and fire based on faith. B. The non-profit is in violation of Title Omen as it prohibits religious discrimination in hiring. C. The non-profit must prove that hiring the employee would impose an undue hardship under Title VI's accommodation standard. D. The non-profit is violating the Equal Protection Clause as it denies employment based on religious belief. Answer A. The non-profit is protected under the ministerial exception, which allows religious organizations to hire and fire based on faith. Explanation. The ministerial exception, upheld in Hosanna Tabor Evangelical Lutheran Church v. EAC 2012, allows religious organizations to hire based on religious criteria when the role involves religious functions. This exemption prevents government interference in religious decision-making. Title Omen prohibits discrimination, but religious organizations are generally exempt when hiring for roles that involve faith-based duties. Question 11. If a constitutional right is selectively applied, a state law allows police officers to search individuals' cell phones without a warrant if they are suspected of gang-related activity. However, other suspected criminals are granted full Fourth Amendment protections. A defendant challenges the law, arguing it violates their equal protection and Fourth Amendment rights. How should the court rule? A. The law is constitutional because gang-related crime is a serious issue requiring proactive measures. B. The law is unconstitutional under the Fourth Amendment, which requires a warrant for cell phone searches. C. The law is unconstitutional under the Equal Protection Clause as it applies different standards based on suspected criminal activity. D. Both B and C are correct. Answer D. Both B and C are correct. Explanation. The Supreme Court in Riley v. California 2014 held that searching a cell phone requires a warrant under the Fourth Amendment. Additionally, the Equal Protection Clause prohibits laws that arbitrarily apply different constitutional protections to different groups without a compelling justification. The state law unfairly targets one category of individuals, making it unconstitutional. Question 12. When legislative actions threaten judicial independence, a state legislature passes a law allowing voters to recall state Supreme Court justices if they issue rulings that conflict with majority public opinion. Several justices challenged the law, arguing it violates the principle of judicial independence under the state and federal constitutions. How should the court rule? A. The law is constitutional because state judges are accountable to the public. B. The law is unconstitutional because it interferes with the judiciary's ability to apply the law without political pressure. C. The law is constitutional under the 10th Amendment as states control their judicial systems. D. The law is unconstitutional because judicial recall is prohibited under federal law. Answer B. The law is unconstitutional because it interferes with the judiciary's ability to apply the law without political pressure. Explanation. Judicial independence is a fundamental principle ensuring that judges apply the law impartially without political or popular influence. The Supreme Court has ruled that judicial decisions should not be subject to public opinion or political retaliation. Republican Party of Minnesota v. White 2002. Allowing judicial recall based solely on rulings undermines this principle. Question 13. If executive power expands beyond constitutional limits, the President issues an executive order requiring all state governments to adopt federal environmental standards, arguing that climate change presents a national security threat. Several states challenge the order, claiming it exceeds executive authority. What constitutional principle is at stake? A. The order is constitutional because the Supremacy Clause gives federal law precedence over state law. B. The order is unconstitutional because the President cannot unilaterally impose regulations on states. C. The order is constitutional under the Necessary and Proper Clause as environmental issues affect national security. D. The order is unconstitutional because environmental policy is exclusively a state power. Answer B. The order is unconstitutional because the President cannot unilaterally impose regulations on states. Explanation. While the Supremacy Clause ensures that federal laws override conflicting state laws, executive orders cannot bypass Congress. The President does not have unilateral authority to impose regulations on states without congressional approval. Young Sound Sheet and 2 Company v. Sawyer, 1952. Question 14. When legislative actions affect fundamental voting rights, a state enacts a law requiring all voters to present a government-issued photo ID before casting a ballot. Advocacy groups challenge the law, arguing that it disproportionately affects low-income and minority voters, violating the Equal Protection Clause and the Voting Rights Act of 1965. How should the court evaluate the constitutionality of this law? A. The law is constitutional because states have a legitimate interest in preventing voter fraud. B. The law is unconstitutional if it imposes an undue burden on the right to vote. C. The law is constitutional because the Elections Clause grants states broad authority over election procedures. D. The law is unconstitutional because all voting restrictions violate the 15th Amendment. Answer. B. The law is unconstitutional if it imposes an undue burden on the right to vote. Explanation. While states have the power to regulate elections, voting laws must not create undue burdens on voters. The Supreme Court ruled in Crawford v. Marion County Election Board 2008 that voter ID laws are permissible only if they serve a legitimate state interest without disproportionately burdening certain groups. Courts apply a balancing test, weighing the state's interest in election security against the burden imposed on voters. Question 15. If the government restricts public speech based on content, a city passes an ordinance prohibiting public demonstrations criticizing the local government. Protesters sue, claiming a First Amendment violation. How should the court rule? A. The ordinance is constitutional because local governments can regulate speech that threatens public order. B. The ordinance is unconstitutional because it imposes a content-based restriction on speech. C. The ordinance is constitutional under the police powers doctrine, which allows cities to regulate protests. D. The ordinance is unconstitutional because it violates the Fourth Amendment's protection against unreasonable restrictions. Answer. B. The ordinance is unconstitutional because it imposes a content-based restriction on speech. Explanation. Content-based restrictions on speech are presumptively unconstitutional under the First Amendment unless they pass strict scrutiny. Reed v. Town of Gilbert, 2015. Governments cannot single out specific viewpoints for suppression. Public speech can only be restricted under narrowly tailored regulations concerning time and manner, but outright bans based on content are unconstitutional. Question 16. When privacy rights conflict with law enforcement authority, a police department begins using drones to surveil private homes without a warrant. Homeowners challenge this practice, arguing it violates their Fourth Amendment rights. How should the court rule? A. The surveillance is constitutional because aerial observation does not constitute a search. B. The surveillance is unconstitutional because using drones to observe private property without a warrant violates Fourth Amendment protections. C. The surveillance is constitutional under the open fields doctrine, which allows observation of property without a warrant. D. The surveillance is unconstitutional only if the drones record audio conversations. Answer. B. The surveillance is unconstitutional because using drones to observe private property without a warrant violates Fourth Amendment protections. Explanation. The Fourth Amendment protects individuals from warrantless searches in areas where they have a reasonable expectation of privacy. Catesby, United States, 1967. The Supreme Court in Florida v. Riley, 1989, ruled that aerial observation may be constitutional, but long-term, intrusive drone surveillance without a warrant is likely unconstitutional under Carpenter v. United States, 2018. Question 17. If government regulations interfere with religious practices, a city bans the ritual slaughter of animals, citing public health concerns. A religious group that practices animal sacrifice as part of its faith challenges the law under the First Amendment's Free Exercise Clause. How should the court rule? A. The law is constitutional because it serves compelling government interest. B. The law is unconstitutional because it specifically targets religious practices. C. The law is constitutional under the Commerce Clause as it regulates trade in animals. D. The law is unconstitutional unless the city can prove rational basis for the restriction. Answer. B. The law is unconstitutional because it specifically targets religious practices. Explanation. Laws that target religious practices are unconstitutional unless they satisfy strict scrutiny. In Church of the Lukumi Bebolu IV, Haile, 1993, the Supreme Court ruled that bans on religiously motivated animal sacrifice violate the Free Exercise Clause when they are not neutral and generally applicable. Question 18. When criminal penalties impact First Amendment protections, the state passes a law making it a crime to publicly criticize law enforcement officers. A journalist is arrested under this law and challenges it on First Amendment grounds. How should the court rule? A. The law is constitutional because law enforcement officials deserve protection from harassment. B. The law is unconstitutional because it criminalizes speech that criticizes public officials. C. The law is constitutional under the public safety exception, which allows for certain restrictions on speech. D. The law is unconstitutional only if it prohibits true statements. Answer: B. The law is unconstitutional because it criminalizes speech that criticizes public officials. Explanation: government officials, including law enforcement, are subject to public criticism. The First Amendment protects political speech, including speech that criticizes the government. New York Times v. Sullivan, 1964. Laws criminalizing criticism of government actors are considered unconstitutional. Viewpoint-based restriction. Question 19. If government actions affect educational freedoms, a state legislature mandates that all public schools include a specific religious doctrine in science classes. Parents challenge the law, arguing that it violates the Establishment Clause of the First Amendment. How should the court rule? A. The law is constitutional because states control educational curricula. B. The law is unconstitutional because it violates the Establishment Clause by promoting religion in public schools. C. The law is constitutional under the Free Exercise Clause as it accommodates religious views. D. The law is unconstitutional only if parents can prove it coerces students into religious beliefs. Answer: B. The law is unconstitutional because it violates the Establishment Clause by promoting religion in public schools. Explanation: public schools cannot promote religious teachings under the Establishment Clause. In Edwards v. Aguilard, 1987, the Supreme Court ruled that requiring the teaching of religious beliefs in science curricula violates the First Amendment. Question 20. When national security concerns conflict with due process rights, the federal government detains an American citizen suspected of terrorism without trial or legal representation, citing national security concerns. The detainee challenges the government's authority, arguing that it violates the Fifth Amendment's Due Process Clause. How should the court rule? A. The detention is constitutional under the president's war powers. B. The detention is unconstitutional because U.S. citizens cannot be denied due process. C. The detention is constitutional under the enemy combatant doctrine, which allows indefinite detention. D. The detention is unconstitutional only if the suspect is later found innocent. Answer: B. The detention is unconstitutional because U.S. citizens cannot be denied due process. Explanation: the Supreme Court ruled in Hamdi v. Rumsfeld, 2004 that U.S. citizens, even if designated as enemy combatants, retain due process rights. Indefinite detention without trial violates the Fifth Amendment. Question 21. When technological advances challenge Fourth Amendment protections, police use artificial intelligence software to scan private emails without obtaining a warrant. The government argues that AI-assisted searches do not constitute a search under the Fourth Amendment because no human directly reviews the emails. How should the court rule? A. The searches are constitutional because AI programs do not involve human investigators. B. The searches are unconstitutional because accessing private emails without a warrant violates the Fourth Amendment. C. The searches are constitutional if the AI scans only for criminal activity. D. The searches are unconstitutional only if the emails are used as evidence in court. Answer: B. The searches are unconstitutional because accessing private emails without a warrant violates the Fourth Amendment. Explanation: Carpenter v. United States, 2018 held that the Fourth Amendment protects digital data. Using AI to scan emails without a warrant violates the expectation of privacy. Courts applied traditional search and seizure rules to digital communications. Question 22. When government-imposed restrictions impact free speech in public forums, a city enacts a law requiring individuals to obtain a permit before engaging in any public demonstration, even in traditional public forums like sidewalks and parks. A group of protesters is arrested for marching without a permit and challenges the law on First Amendment grounds. How should the court rule? A. The law is constitutional because cities can regulate the use of public spaces. B. The law is unconstitutional because prior restraints on speech are impermissible. C. The law is constitutional only if it provides a clear, objective permitting process. D. The law is unconstitutional unless the city can prove a compelling state interest. Answer: C. The law is constitutional only if it provides a clear, objective permitting process. Explanation: while the government can impose reasonable time, place, and manner restrictions. These regulations must be content neutral, narrowly tailored, and leave open alternative channels for communication. Ward v. Rock against Racism, 1989. If a permit system is arbitrary or lacks objective standards, it could be an unconstitutional prior restraint. Question 23. When religious liberty conflicts with public health mandates during a pandemic, a state imposes strict capacity limits on public gatherings, including houses of worship. Religious leaders challenge the law, arguing it violates their First Amendment right to freely exercise religion. How should the court rule? A. The restrictions are constitutional if they apply equally to religious and secular gatherings. B. The restrictions are unconstitutional because they interfere with religious observance. C. The restrictions are constitutional under the compelling interest doctrine, which allows states to limit religious practices for public health reasons. D. The restrictions are unconstitutional unless they are the least restrictive means of achieving public safety. Answer A. The restrictions are constitutional if they apply equally to religious and secular gatherings. Explanation. Under Employment Division v. Smith, 1990, neutral laws of general applicability that do not specifically target religion are generally constitutional. However, in Roman Catholic Diocese of Brooklyn v. Cuomo, 2020, the Supreme Court ruled that if secular gatherings, e.g., grocery stores, receive more treatment than religious ones, such restrictions violate the Free Exercise Clause. Question 24. When digital privacy rights are at stake, a social media company collects vast amounts of user data, including private messages, and shares it with law enforcement without requiring a subpoena. A user sues, claiming a violation of their Fourth Amendment rights. How should the court rule? A. The data collection is constitutional because users voluntarily provide information to the platform. B. The data collection is unconstitutional because private messages require a warrant under the Fourth Amendment. C. The data collection is constitutional if users have agreed to the platform's terms of service. D. The data collection is unconstitutional unless the government proves probable cause before obtaining data. Answer B. The data collection is unconstitutional because private messages require a warrant under the Fourth Amendment. Explanation. In Carpenter v. United States, 2018, the Supreme Court ruled that certain digital data, such as location records, require a warrant under the Fourth Amendment. Courts are increasingly recognizing that users have a reasonable expectation of privacy in their digital communications. Question 25. When political speech is regulated during elections, a state enacts a law prohibiting corporations and unions from spending money on political advertising within 60 days of an election. A corporation challenges the law, arguing it violates its First Amendment rights. How should the court rule? A. The law is constitutional because states can regulate corporate political activity. B. The law is unconstitutional because political expenditures are a form of protected speech. C. The law is constitutional under the Campaign Finance Reform Act, which limits corporate influence in elections. D. The law is unconstitutional only if it restricts independent political expenditures. Answer B. The law is unconstitutional because political expenditures are a form of protected speech. Explanation. In Citizens United v. Feck, 2010, the Supreme Court ruled that corporate and union expenditures on political speech cannot be limited under the First Amendment. The court held that political spending is a form of protected speech and restrictions on independent expenditures violate free expression. Question 26. When hate speech laws conflict with free expression, a state passes a law criminalizing speech that insults or offends individuals based on race, gender, or religion. A protester is arrested under this law and challenges it on First Amendment grounds. How should the court rule? A. The law is constitutional because hate speech is not protected under the First Amendment. B. The law is unconstitutional because offensive speech is protected unless it incites violence. C. The law is constitutional under the Fighting Words Doctrine, which allows punishment for offensive speech. D. The law is unconstitutional only if it restricts political speech. Answer B. The law is unconstitutional because offensive speech is protected unless it incites violence. Explanation. Hate speech is generally protected under the First Amendment unless it constitutes true threats or incitement to imminent lawless action. Brandenburg v. Ohio, 1969. In R.I.V. v. City of St. Paul, 1992, the Supreme Court struck down laws that prohibit speech based on its content alone. Question 27. When national security interests conflict with individual liberties, a government agency requires all employees to undergo continuous electronic surveillance to prevent security leaks. An employee challenges the practice, claiming it violates their Fourth Amendment rights. How should the court rule? A. The surveillance is constitutional because national security justifies warrantless monitoring. B. The surveillance is unconstitutional because government employees have a reasonable expectation of privacy. C. The surveillance is constitutional under the Public Employment Doctrine, which limits privacy rights for government workers. D. The surveillance is unconstitutional unless it is narrowly tailored to specific threats. Answer D. The surveillance is unconstitutional unless it is narrowly tailored to specific threats. Explanation. The Fourth Amendment protects against unreasonable searches and seizures even in the workplace. In Nassar v. Nelson 2011, the Supreme Court recognized that government employees have privacy rights, but limited intrusions may be permissible if justified by compelling interests. Question 28. When search and seizure laws are tested in schools, a high school principal conducts random locker searches without individualized suspicion, arguing that school safety justifies the practice. A student challenges the searches as a violation of their Fourth Amendment rights. How should the court rule? A. The searches are constitutional because students have limited privacy rights in schools. B. The searches are unconstitutional because they require probable cause. C. The searches are constitutional only if schools can prove an immediate security threat. D. The searches are unconstitutional unless students provide prior consent. Answer A. The searches are constitutional because students have limited privacy rights in schools. Explanation. In New Jersey v. T.L.O. 1985, the Supreme Court ruled that schools could conduct searches based on reasonable suspicion, a lower standard than probable cause. Students have reduced privacy rights in school settings, but searches must still be reasonable in scope. Question 29. When artificial intelligence is used for government surveillance, a city implements an AI-powered facial recognition system that scans all public spaces, including sidewalks and parks, without warrants. Civil rights groups challenge the program, arguing it violates the Fourth Amendment. How should the court rule? A. The surveillance is constitutional because there is no expectation of privacy in public spaces. B. The surveillance is unconstitutional because mass collection of biometric data without individualized suspicion violates the Fourth Amendment. C. The surveillance is constitutional under the Open Fields Doctrine, which allows observation of public areas. D. The surveillance is unconstitutional only if it is used for law enforcement purposes. Answer B. The surveillance is unconstitutional because mass collection of biometric data without individualized suspicion violates the Fourth Amendment. Explanation. The Fourth Amendment protects against mass surveillance that collects and stores biometric data without consent. In Carpenter v. United States 2018, the court ruled that prolonged government tracking without a warrant raises constitutional concerns. Courts are likely to extend these principles to AI surveillance. Question 30. When compelled speech laws are challenged, a state enacts a law requiring private businesses to display government-mandated messages about social issues, even if the business owners disagree with the message. A business owner sues, arguing the law violates the First Amendment by compelling speech. How should the court rule? A. The law is constitutional because the government can regulate commercial speech. B. The law is unconstitutional because the government cannot compel private individuals to express specific messages. C. The law is constitutional under the government speech doctrine, which allows the government to promote its own message. D. The law is unconstitutional only if the message is political in nature. Answer B. The law is unconstitutional because the government cannot compel private individuals to express specific messages. Explanation. The First Amendment protects against compelled speech. In Woolley v. Maynard, 1977, the Supreme Court ruled that forcing individuals to display a state slogan on their license plate violated free speech rights. Similarly, in West Virginia State Board of Education v. Barnett, 43, the court held that students could not be forced to salute the flag or recite the Pledge of Allegiance. The government cannot force private individuals or businesses to express viewpoints they disagree with.